Welcome to NIOS live classes. Subject Political Science Senior Secondary. Module number 3 Structure of Government. Lesson number 12 Supreme Court of India. Part 1. Outcomes. After studying this lesson, learner will recognize that India has a single, integrated and unified judicial system. They can describe the composition and organization of the Supreme Court of India. They can also explain the power and jurisdiction of the Supreme Court of India. And can able to appreciate the role of Supreme Court of India as guardian of the Constitution and can be a protector of fundamental rights. Before reading the lessons, we will learn some difficult words for the better understanding. First is court. As you can see on the screen, in India there is a two type of courts, which is High Court and Supreme Court. Next is collegium. Next is original jurisdiction. Next is appellate jurisdiction. Next is court of record. Next is protection. Next is guardian of the Constitution. Next is civil cases and criminal cases. There is a civil cases which is related to properties, complaints, theft, etc. These cases include not too much dangerous but criminal case includes all type of dangerous cases like killing, murdering, rape, etc. Next is public interest litigation. In short, we can call it PIL. Next is judicial review. And last is judicial activism. Now we have learned our difficult word, so we can begin with our chapter. And the topic is single, unified and integrated judicial system. The distinct feature of our judiciary is that it is a single, unified, integrated judicial system for the whole country. A single judiciary represents a hierarchy of courts. As you can see, side on the screen there is a table. Through combining them, we can identify that the Supreme Court stands at the top of this single integrated judicial system with high courts at the state level. Below the high courts, there are several subordinate courts such as district court, which deal with civil cases, and session courts, which decide criminal cases. Indian judicial system. As you can see on the screen, there are three types of courts, which is subordinate courts, High Court and Supreme Court. Now at first we will look what is Supreme Court and what's it's doing. Supreme Court is the highest judicial authority of India. It consists of the Chief Justice and 25 other judges in it. The Parliament may increase the number of judges if it deems necessary. In Supreme Court, beside the Chief Justice, there were only 7 other judges. The Parliament has increased the number of judges from time to time. As in 2005, there are 25 judges besides the Chief Justice, who is called the Chief Justice of India. The Chief Justice and other judges of the Supreme Court are appointed by the President of India. While appointing the Chief Justice, the President is constitutionally required to consult such other judges of the Supreme Court, so he seems proper. But outgoing Chief Justice is always consulted. Normally, the senior most judge of the Supreme Court is appointed as the Chief Justice of India. Although there is no constitutional requirement to do so. While appointing other judges, the President is bound to consult the Chief Justice and other senior judges if he seems proper. Whenever there is vacancy or a likely vacancy in Supreme Court, the Chief Justice and 4 other senior most judges consider various names and recommend the names of the persons to be appointed as judges of the Supreme Court. This system is based on a ruling of the Constitutional Bench of a Supreme Court, which is handed down in 1993 and reinforced in 1999. Thus, while the Constitution still provides that the President is the appointing authority of the Supreme Court judges, the ruling of the Supreme Court has since 1999 become virtually binding on the President. The power of section of judges has passed on to a group of Supreme Court judges called Collegium of the Court. The President now performs the formality or appointing the nominee of the Supreme Court. After the law, ministry formally recommends these names to him. Let's take a short break.
जीवन ये प्रकाशित करने राहों को आलोकित करने हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने। हम
अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने।
जीवन ये प्रकाशित करने राहों को आलोकित करने
सीमा से विद्यालय जो मुक्त हो,
संसाधन समय की सीमा से विद्यालय जो मुक्त हो।
कभी पढ़े हम कहीं पढ़े वे विषय की लोच से युक्त हो।
कभी पढ़े हम कहीं पढ़े वे विषय की लोच से
और जागे
मंजिल आने की ध्वनि सुने। हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने।
जीवन ये प्रकाशित करने राहों को आलोकित करने
बार ही क्यों मिलता
परीक्षा का अवसर एक बार ही क्यों मिलता फिर दुनिया में इसके केंद्र बात
कोई मन चाहा केंद्र चुने हम अपना जीवन स्वयं बने हम अपना रास्ता स्वयं चुने कोई मन चाहा केंद्र चुने स्वयं बने हम
Welcome back to our classes. Now we will look what's the qualification need for these codes. A person is qualified for appointment as a judge only he or she is a citizen of India, as if he or she fulfills one of the following conditions. First, he or she has been for at least 5 years a judge of as a high court or 2 or more than 2 such courts. Second, he or she has been for at least 10 years an advocate of a high court or 2 or more than 2 such courts. C, he or she is, in the opinion of the President, a distinguished jurist. Now we will look what is tenure. The Chief Justice of the India and other judges of the Supreme Court hold office till they attain the age of 65. Second, a judge may voluntarily resign before expiry of his term. Next, in exceptional cases, a Supreme Court judge may be removed before the age of retirement, according to the procedure laid down in the Constitution. Now we will understand what's the meaning of removal. A judge of Supreme Court can be removed from office by an order of the President passed after an address by each house of the Parliament supported by a majority of total membership of the House and not less than 2/3 majority of the member of the House. The House present and voting passes in the same session has been presented to the President for such removal on the ground of proved misbehavior or capacity. So far, proceeding for removal were initiated only in one case against a judge of the Supreme Court, but he or she could not be removed because the resolution could not be passed by the Parliament. But it is clear that Supreme Court judges enjoy security of tenure and the executive cannot arbitrarily remove them. No person who has held office of a judge of the Supreme Court is allowed to plead as an advocate in any court or before any authority within the territory of India. Supreme Court judge cannot be a lawyer for anyone. The judge of the Supreme Court are paid such salaries as they determined by the Parliament from time to time. Next we will study Court of Record. The Supreme Court is a court of record. But it has two implications. First, all its decisions and judgments are cited as precedents in all courts of the country. They have the force of law and are binding on all lower courts and indeed the high courts. As a court of record, the Supreme Court can even send a person to jail who may have committed contempt of the court. Jurisdiction of the Supreme Court. The scope of power of Supreme Court to hear and decide cases is called its jurisdiction. The Supreme Court has three types of jurisdictions, namely original, appellate and advisory. Now first we will look what is original jurisdiction. There are certain cases which fall within the exclusive jurisdiction of the Supreme Court. It means that all such cases begin or originate in the Supreme Court only. It also means that cases cannot be initiated in any other court. The cases or disputes that come under the original jurisdiction are given below, which is first is it disputes between the Government of India on the one side and or more states on the other sides. Second, it disputes between the Government of India and one or more states on one side and one or more states on the other side. And third is it disputes between two more states. The Supreme Court has been invested with special powers in the enforcement of fundamental rights. In this connection, it has the power to issue directions or writs. Cases under public interest litigation. In short, we can say PIL can also be heard directly. This is an extra constitutional practice. There is no mention of PIL in the Constitution. Let's take a short break.
जीवन ये प्रकाशित करने, राहों को आलोकित करने,
जीवन ये प्रकाशित करने, राहों को आलोकित करने, हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने,
अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने।
जीवन ये प्रकाशित करने, राहों को आलोकित करने।
धन साधन समय की सीमा से विद्यालय जो मुक्त हो,
धन साधन समय की सीमा से विद्यालय जो मुक्त हो।
कभी पढ़े हम कहीं पढ़े, वे विषय की लोच से युक्त हो।
कभी पढ़े हम कहीं पढ़े, वे विषय की लोच से युक्त हो।
मित्रों हम उठे और जागे,
मंजिल आने की ध्वनि सुने, हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने।
जीवन ये प्रकाशित करने, राहों को आलोकित करने।
राष्ट्रीय मुक्त विद्यालय का है द्वार खुला सबकी खातिर।
शिक्षा परीक्षा का अवसर एक बार ही क्यों मिलता फिर।
शिक्षा और परीक्षा का अवसर एक बार ही क्यों मिलता फिर। दुनिया में इसके केंद्र बात,
कोई मन चाहा केंद्र चुने, हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने। कोई मन चाहा केंद्र चुने, हम स्वयं बने, हम
Welcome back to our classes. Now we will learn what is appellate jurisdiction. The power of superior or higher court to hear and decide appeals against the judgment of a lower court is called appellate jurisdiction. The Supreme Court has vast appellate jurisdiction. It hears appeals against the judgment of the high courts. It is the highest and the final court of appeal if one of the parties to a dispute is not satisfied with the decision of High Court. One can go to Supreme Court and file an appeal. The appeals can be filed in civil, criminal and constitutional case. Now we will look what is appeals in civil cases. Civil cases, disputes relating to property, marriage, money, contract and service etc. are called civil cases. If a civil case involves a substantial point of law of public importance needing interpretation of the constitution or law, an appeal against the High Court decision can be made to Supreme Court. Earlier, the financial limit of such civil cases was rupees 20,000, but now according to the 30th Amendment of 1972, there is no minimum amount for taking a civil appeal to the Supreme Court. If substantial question of interpretation of law or constitution is involved, appeal may be made against the decision of the High Court. Appeals in criminal cases. An appeal may be brought to the Supreme Court against the High Court decision in a criminal case in a number of situations. Firstly, if a high court sets aside an appeal or an order of acquittal passed by a lower court and awards death sentence to the accused, he may bring an appeal to the Supreme Court by right. Secondly, appeal can be made to the Supreme Court if the higher court withdraw a case from a lower court to itself. It declares the accused guilty and awards death sentence. For instance, we can look at Nirbhaya case in Delhi. In this situation, also, appeals can be made as a matter of right and without certificate from the High Court. The appeal in cases other than these two categories may also be brought to the Supreme. Cases related to violations of fundamental rights and PIL can be directly appealed in Supreme Court or High Court. Court provided the High Court grant a certificate that the case is fit for appeal to the Supreme Court. Appeals in constitutional cases. A constitutional case is neither a civil dispute nor concerning a crime. These cases related to writs which involves violation of fundamental rights, for example, Keswananda Bharati case, where basic structure of constitution cannot be changed, was defined. It is a case arising out of different interpretations of constitution, mainly regarding the fundamental rights. In such constitutional cases, an appeal can be taken to the Supreme Court only if higher court certifies that the matter in dispute involves a substantial question of law. If the High Court denies a certificate of fitness to appeal to the Supreme Court, the Supreme Court can use its discretion and grant special leave to appeal to itself in any case it seems fit. Now we will look at the advisory jurisdiction. This power implies court's right to give advice if sought. Under advisory jurisdiction, the President of India may refer any question of law or public importance to Supreme Court for its advice. but the Supreme Court is not bound to give advice. In case